What next for S. Iswaran? The former minister is likely facing jail time after pleading guilty and being convicted of 5 charges, 4 for obtaining valuable things as a public servant and 1 for obstructing justice. His sentencing is on October 3rd. Let's get to the point with senior law correspondent Selina Lum. Shortly after the charges were issued back in January, Iswaran pleaded not guilty to all the allegations, only to plead guilty to 5 counts yesterday. It came after, among other things, amendments to the 2 corruption charges to Section 165 charges. So could you elaborate on how this all could have led to the 11th hour guilty plea?
So just to set some explanation, in a typical criminal case, there's actually a lot of to and fro between the prosecution and the defense. This is called making representations by the defense, when the defense lawyer would write in to try to bargain with the prosecution in the hope of securing the best outcome for the client. So in court yesterday, we learned that further representations were made to the prosecution, and in response, the prosecution agreed to amend 2 of the corruption charges to Section 165 charges. So in court yesterday, Iswaran's lawyer, Senior Counsel Davinder Singh, made the point that with the charges being amended, Iswaran believed that it was the right thing to do, to accept that he was wrong, to have accepted the gifts. And Mr. Singh also made the point that Iswaran was very mindful of not wanting the people whom he loved the most, which is his family, to continue to bear the toll of what had happened. He didn't elaborate. As for why the prosecution decided to amend the charges, the Attorney General's chamber said that it considered the litigation risk involved in proving the corruption charges beyond a reasonable doubt during the trial. And the prosecution said that this is because there are 2 primary parties to a transaction, and both parties would have an interest in denying that there was corruption. So what they're basically saying is that in a trial, anything can happen and witnesses can turn hostile. And the bar to actually prove a charge beyond reasonable doubt is actually quite high. By having this plea deal, removes the uncertainty that comes with a trial. Thus, a conviction is secured, and Iswaran is held accountable in some ways for what he had done.
So the prosecution has sought a jail term of 6 to 7 months, while Iswaran's lawyer has argued for no more than 8 weeks jail. What sentence could Iswaran face?
Both sides have agreed that Iswaran should go to jail. The only difference is for how long. Iswaran's lawyer was trying to argue that deterrence has already been achieved based on the mere fact that Iswaran was charged, and there can be no doubt that public servants will take note of this and will be mindful not to do such things again. But the prosecution made the point that it's important to send a signal, and deterrence is not achieved simply by charging someone in court, and the court should send a signal to the public about the seriousness of such offences by the sentence that it imposes. The prosecution did ask the court to set what it called a marker on what level of punishment should be appropriate for Iswaran's case. Ultimately, it is up to the judge to decide what is the appropriate sentence. And in fact, the judge in this case has brought up a Malaysian case and asked the prosecution and the defense to give their further submissions on this. And it's a case where a chief minister of Selangor was sentenced to a year's jail for a Section 165 offence.
And what will happen to Mr. Ong Beng Sing and Mr. Lam Kok Sing? They've been named in several of Iswaran's charges but haven't been charged themselves. Can they still be charged though?
So Iswaran's charges actually arose out of his dealings with these 2 men. Pertinent to note that out of these 2, only Mr. Ong has been implicated in a corruption charge. But now that the corruption charge has been amended, of course, the question remains is what's going to happen to him. Mr. Ong had been arrested, but he was never charged. Mr. Lam, no charges has been filed against him, and he was never put on any restrictions by the CPIB. Section 165, unlike a corruption charge where you can prosecute both the giver and the receiver of a bribe, Section 165 targets only public servants. So the question is, can these 2 people, would these 2 people face prosecution? In Brunei, there's a case where someone was convicted for abetting a Section 165 charge. But whether that happens in Singapore, of course, remains to be seen. We did ask the Attorney General's chambers yesterday what decision will be taken in respect of Mr. Ong and Mr. Lam. The agency responded that it will take a decision in respect of Mr. Ong soon.